Hello, everyone. Welcome to the Case for an Activist Judiciary featuring Justice Clint Bolick of the Arizona Supreme Court and Professor Keith Whittington. We will get started here. So Clint Bolick was appointed by Governor Doug Ducey in January 2016 to serve on the Arizona Supreme Court, and in 2018 he was retained by the voters for a 6-year term. Prior to joining the court, Justice Bolick litigated constitutional cases in state and federal courts from coast to coast, including the U.S. Supreme Court. Among other positions, he served as vice president for litigation at the Goldwater Institute and as co-founder and vice president for litigation at the Institute for Justice. He litigated in support of school choice, freedom of enterprise, private property rights, freedom of speech, and federalism, and against racial classifications and government subsidies. Justice Bolick received his Juris Doctor degree from the University of California at Davis, where he has been recognized as a distinguished alumnus, and his Bachelor of Arts degree, magna cum laude, from Drew University. He serves as a research fellow at the Hoover Institution. Among other honors, he was named one of the 90 greatest DC lawyers in the last 30 years by Legal Times in 2008, received a Bradley Prize in 2006, and was recognized as one of the nation's 3 Lawyers of the Year by American Lawyer in 2002 for successful defense of school vouchers in Zellman v. Simon Harris. Justice Bolick is a prolific author of a dozen books and hundreds of articles. Among his most recent books are Immigration Wars, Forging an American Solution, co-authored with former Florida Governor Jeb Bush, and David's Hammer, The Case for an Activist Judiciary. Bolick serves as an adjunct professor of constitutional law at Arizona State University's Sandra Day O'Connor School of Law, and at the University of Arizona James E. Rogers College of Law, and has served as a lecturer at Harvard University's John F. Kennedy School of Government. Please join me in welcoming Justice Clint Bolick.
Thank you so much, Patrick. It's such a pleasure to be with you. I was actually going to say that I wish it was in person, but it is in the low 70s here in Arizona. So if it were another day, I do wish that I was there in person. What a pleasure to be hosted both by the Princeton University Libertarians and also by the Federalist Society. For those of you who are watching who are not from New Jersey, as a New Jersey boy, I have to tell you to eat as much pizza as you possibly can during your Princeton days. Once you leave New Jersey, you're not going to get it. Very good pizza. I grew up in New Jersey, in that part of the turnpike where people always say, "Oh my gosh, what's that awful smell?" And I did go to Drew University, which aspires to be Princeton, but whenever it seeks to compete, Princeton simply says, "What's Drew University?" But I do miss New Jersey, and I hope that I have another opportunity to visit. I really am honored to have comments on this talk today from Professor Keith Whittington. In fact, the roles really should be reversed. He should be speaking on this topic, and I should be, I don't know, serving drinks or collecting tickets or something like that. But you guys are so lucky to have him as a professor. I'm really looking forward to his comments later on. And if any of you happen to have a class with Professor George, I hope you will extend to him my warmest wishes as well. This talk today is based on a book that Patrick mentioned in the introduction that I wrote for the Cato Institute in 2007 called David's Hammer, The Case for an Activist Judiciary. And the term judicial activism is one of the few things in which conservatives and liberals agree. They hate judicial activism. And I intentionally chose that title because, or that subtitle, because it is a provocative subtitle. Judicial activism is the universal pejorative. And in fact, when I was writing the book, the Cato Institute urged me not to use that subtitle. They said, it's too controversial. No one likes it. Yes, it may be provocative. And their ace in the hole was, if you have this as your subtitle, you will never be appointed to the judiciary. And my response to that was, you know what? I'm never getting appointed to the judiciary anyway, so I may as well go ahead and use the provocative title. And when I was appointed by Governor Ducey in 2016 to the court, indeed, it was a controversial subtitle. I was asked about it during the appointment process on numerous occasions, and I loved talking about it. And I think that the way I explained judicial activism was palatable to the folks who were involved in the appointment process. Would I be appointed to the New Jersey Supreme Court by Governor Murphy if I were still there? Odds are not very good that I would. So I guess I'm at the right place at the right time, and just having a blast. And it is just an incredible honor to be on the Arizona Supreme Court. What do I mean by judicial activism? I mean something very simple: courts striking down unconstitutional laws, and not doing so because they feel like it or because it offends their policy views, but striking down unconstitutional laws in accord with the text and the original understanding of the Constitution of the United States. The opposite of judicial activism, in my view, is judicial abdication. That is where courts consider a law that is, in fact, unconstitutional, and for one reason or another find a way to uphold it, whether it's by a presumption of constitutionality or some sort of procedural obstacle that prevents the law from being struck down. I juxtapose judicial activism with what I call judicial lawlessness. And that is when the judiciary goes beyond its assigned constitutional duty to strike down unconstitutional laws to take on powers that are not judicial powers, specifically executive powers or legislative powers. And indeed, courts do that quite frequently. And I'll mention toward the close of my talk exactly that phenomenon. It's a very, very dangerous phenomenon. And I think that courts have plenty to do in dealing with unconstitutional laws without having to get into the executive or legislative arenas. I believe that my view of judicial activism reflects exactly the role, the very crucial role that the framers assigned to the judiciary. This role is best articulated in the Federalist number 78, and subsequently in Marbury versus Madison, which recognized the role of the courts in policing the boundaries of the other two branches of government. In the Federalist number 78, Alexander Hamilton, whose reputation is soaring these days, argued that the judiciary was necessary because the propensity of both the legislative and the executive branches would always be to expand their powers beyond their constitutionally assigned boundaries. And we needed an independent governmental entity whose role it would be to police those boundaries and to strike down laws that exceed those boundaries or that violate individual rights. At the very same time, Hamilton warned that although the judiciary ought to be and would be the weakest of the three branches of government because its powers were so narrowly defined, it could be a very dangerous branch if it were ever to assume executive or legislative powers. And I think that's absolutely right. And in fact, some of the worst examples of the judiciary exceeding its powers involve exactly those kinds of instances. Now, I submit that the main problem with judicial activism today is not that there's too much of it, but that there's much too little of it. That there should be far more court opinions that strike down laws as unconstitutional. Why is that? Well, the explanation is that the government at every level, from the national government down to your local zoning commission, the power of government and the size and scope of government has grown exponentially. And court decisions keeping up with that growth of government and striking down laws as exceeding constitutional boundaries, it simply hasn't kept up. Two examples from my book. It took the US Code, which is the compilation of all of the national laws, 169 years to reach 11,000 pages. So 169 years to reach 11,000 pages, compiling all of the laws of the national government. It took only 40 years more after that for the US Code to quadruple in size. And that was as of 2007 when I wrote the book. And, that's pre-Obamacare and a lot of other big federal laws. So federal laws are growing at an incredible clip. Federal regulations, even more so. Between 1960 and 2007, when I wrote the book, the number of federal regulations increased by 700%. And so if the number of unconstitutional laws and regulations, or I should say the percentage of regulations and laws that are unconstitutional simply stayed constant, we should see something like between 4 and 7 times the number of court decisions striking down laws as unconstitutional, if in fact that held constant. That is, that the percentage of laws and regulations that violate the federal constitution remain the same. But there are indications that in fact the percentage of laws that are unconstitutional has actually increased. And the reason for that is really, I used the word abdication before in the context of the judiciary, but in the context of the executive branch and the legislative branch, they too take oaths to the Constitution, but they spend an awful lot less time than they used to assessing whether their actions are constitutional or not. If you go back to the 19th century and you look at congressional debates over federal legislation, you will see that they spend a tremendous amount of time with the threshold issue of whether what they want to do is within their constitutional powers or not. The Civil Rights Act of 1866, which I'll talk about in a couple of moments, is an example where Congress was just consumed with the question of whether it had the power to enact a Civil Rights Act at all. Fast forward to 2021, how often do you hear a legislator, or for that matter, the President of the United States, whether Democrat or Republican, asking the question, is this within our congressional power? When Obamacare passed, Nancy Pelosi famously said, we need to pass the law in order to see what's in it. And an even worse example was when President George W. Bush signed the McCain-Feingold campaign finance law. And he said, I think that there are provisions in this bill that are probably unconstitutional, but I'll leave it to the courts to figure that out. Well, we have lost the self-restraint that legislative and executive actors used to have. And as a result, it does fall to the courts to police the boundaries of those two branches of government and to protect individual rights. I'm going to just talk about two examples of judicial abdication and then conclude for Professor Whittington to provide some comments and hopefully get some questions or comments from you. The first is one of my favorites, and in fact, I devoted an entire other book to this subject. And it is the evisceration of the protection of freedom of enterprise in our Constitution. I mentioned the Civil Rights Act of 1866. After the Civil War, the newly freed slaves went into business for themselves, went into occupations for themselves, and the Southern legislatures were bound and determined to prevent that economic emancipation. So they passed a series of laws called the Black Codes that were designed to eviscerate the right of freedom of contract, the right of what they called at the time free labor, the right to sell your labor to others, to engage in businesses, private property rights, and so forth. And Congress responded by passing the Civil Rights Act of 1866, which was designed precisely to protect those rights. In turn, Congress feared that that law was unconstitutional, so they constitutionalized that law in the 14th Amendment, which was adopted shortly after the Civil War, and which, among other things, that the most famous things it protects are due process and equal protection. But its first protection, even before due process and equal protection, is the protection of the privileges or immunities of citizens, which were intended to protect not only the Bill of Rights against the states, which were frequent violators of those civil rights, but the right to earn an honest living. No sooner did the ink dry on that provision than in a case called the Slaughterhouse cases, aptly named, the Supreme Court, by a 5-4 ruling, very unusual in those days, literally wrote the Privileges or Immunities Clause out of the Constitution. The history since then is rather torturous, but basically that fundamental civil right has largely been unprotected, not by an act of judicial activism where the court should have struck down the state's arbitrary and protectionistic constraints on economic freedom, but by an act of judicial abdication where the court looked at the words privileges or immunities and said, that really doesn't protect a whole heck of a lot. In fact, almost nothing. And the dissenters in that case said, we fought a civil war over nothing. These rights are the right of all free men. And by that decision, the court essentially eliminated one of our most fundamental rights, and it remains so to this day. When I worked during the Reagan administration at the EEOC for a then obscure chairman named Clarence Thomas, we totally nerded out over the slaughterhouse cases. And I'm happy to say that as a justice in a case involving Second Amendment rights, McDonald versus City of Chicago, he wrote a blistering 40-some page concurring opinion urging that slaughterhouse be overturned. That's just one example. Another was a case from my own court just a couple of weeks ago. And by the way, if any of you either want a cure for insomnia or want to do some further reading, all of my opinions are on a website called azjustice44.com. That would be yours truly. It's azjustice44.com. And this recent case is a case called State versus Mixton, in which the question before the court was whether the police can obtain IP addresses and ISP information without a warrant. Under the Fourth Amendment of the Constitution, under current jurisprudence, the answer to that question seems to be yes. They can, the police can obtain your IP address and your ISP data, which of course allows the police to track your internet activities without a warrant under the Fourth Amendment. Under the Arizona Constitution, as the new constitutions began to emerge in the West, a lot of the framers of those state constitutions said, what can we do to improve upon the US Constitution as interpreted by the US Supreme Court and to provide greater protections of individual rights and constraints on the power of government than the US Constitution does. And in Arizona, an explicit privacy protection was placed into our Constitution, which reads, "No person shall be disturbed in his private affairs or his home invaded without authority of law." My court, by a 4-3 decision over a dissent by yours truly, joined by 2 other justices, said that that provision really means exactly the same thing as the Fourth Amendment, even though those words don't, the words of the Fourth Amendment were actually rejected by our Constitution's framers in favor of a broader and more specific privacy protection. And as a result, those words, the meaning of those words, the vitality of those words is right now in very, very serious question with real ramifications for people and their internet privacy. Those are just 2 examples among many. Eminent domain, where the US Supreme Court in the Kelo decision replaced the words public use as a limitation on eminent domain power with public purpose, which is far more forgiving of government action. Many other examples we could talk about, but I think that you get the point. It's that if the courts do not strictly enforce the terms and protections of the Constitution against the other branches of government and local governments, then those rights really don't exist. What do the people do? Do they pass new constitutional provisions that say the same thing? We all know how hard it is to amend the US Constitution. It's somewhat easier to amend state constitutions, but even then, if the courts are not prepared to vigorously enforce those rights, then those rights really cease to exist. The situation is certainly not all bleak. For example, the US Supreme Court, at the very time when freedom of speech is under greater threat than any time I've seen in my lifetime, is the most pro First Amendment court I've ever seen. And that includes both liberals and conservatives. And they are quite willing to strike down laws that are unconstitutional. Do I see things differently now that I'm a judge than when I wrote David's Hammer in 2007? Not really on the judicial activism side, but I do find that on the other side of the equation, judges love to rewrite laws. If a law just maybe wasn't written as the framers might have intended, the drafters might have intended, the courts are very often willing to rewrite those laws. I think that's a very dangerous thing, and I have actually dissented on many occasions from court decisions from my court that improved upon the handiwork of the drafters of the laws. Justice Scalia was a huge opponent of that sort of thing, saying, listen, legislators put out garbage all the time, and it's our constitutional obligation to let them do that and not to improve upon their handiwork. If they want to correct their mistakes, it's their job to do that, not ours. He said famously, garbage in, garbage out. The one thing that I have done in this regard that I really particularly enjoyed doing, and I think I'm the first judge in the country to do it, was in a concurring opinion in a case called State versus Arevalo, which is also on my website. Joined by one colleague, I argued that the presumption of constitutionality, which courts always apply to laws, is itself unconstitutional. That the scales of justice should never be tipped in favor of the government. If someone comes in and says a law is unconstitutional, we should not indulge any presumptions whatsoever. We shouldn't rewrite laws. We should interpret laws if they're ambiguous in a way that will uphold their constitutionality as a matter of comedy between the courts and the legislature. But we should never presume that a law is unconstitutional, because that all by itself drains the Constitution of the precious liberties that it was intended to protect. With that, I just want to say I am always happy to have dialogue. For those of you who are thinking of going to law school, I am always available by email. I enjoy having those kinds of interactions. Congrats on being at one of the greatest schools, not only in the country, but in the world. And I hope you enjoy it, and that you take what you learn at Princeton and go out and change the world. Thanks so much for having me.
Thank you so much, Justice Bolick, for your incredibly eloquent and substantive presentation, as well as your kind comments at the end. I'm honored to introduce Professor Keith E. Whittington, who is the William Nelson Cromwell Professor of Politics at Princeton University. He has been a visiting professor at the University of Texas School of Law and Harvard Law School. Additionally, Professor Whittington is a member of the American Academy of Arts and Sciences. He did his undergraduate work at the University of Texas at Austin and completed his PhD in political science at Yale University. He writes about American constitutional law, politics, history, and American political thought. Coincidentally, he is also teaching a course this semester called American Political Thought. Professor Whittington's work has appeared in the Wall Street Journal, the Washington Post, the New York Times, the Atlantic, and many other outlets. He has also authored several books. And with that, I virtually hand the mic over to Professor Whittington.
So thank you very much. I appreciate it. I just want to add a little bit of additional context, really, and then get out of the way so y'all can have an opportunity to ask questions. I have to admit, on a day like today, Arizona sounds particularly good, especially for someone who grew up in Texas, where it was cold if it got to like 40. So I'm not enjoying it during this time of year, but what can you do? So I've been really impressed since the advent of the Federalist Society chapter here at Princeton at the quality of the people that y'all have been able to get to come in to speak to you. And I hope you're appreciative of the quality of the people you're getting, because you are really getting some really first-rate legal minds coming through, and these are great opportunities, all things considered. And so I wanted to begin, I think, a little bit by actually contextualizing Justice Bolick a little bit more. So, you know, you're used to these things, hearing the biography, and people do a lot of stuff. You're like, yeah, very impressive. But Justice Bolick really is one of the leading lights in the conservative legal movement. He was one of the co-founders of the Institute for Justice, which is one of the most prominent and most successful public interest law firms on the political right, particularly libertarian. It focuses particularly on property rights issues and criminal justice issues, as well as a smattering of other things. And it has been extraordinarily successful. It has really reshaped the legal landscape and has done some really impressive work. And one consequence of all that impressive work on behalf of libertarian legal causes, that if you had asked me 10 years ago, would Clint Bolick ever be on any bench anywhere, I would have said not a chance would he actually get that kind of opportunity. And so it is a really remarkable time that people like Justice Bolick can find themselves on the state high court doing very good work from the other side of the bench. And I think it's why I take it one of those things that sort of gives me some optimism about where we are. There's a lot of things that make me very pessimistic about the state of the conservative movement these days, including the conservative legal movement. And so I really grab hold of those things that make me more optimistic about where things are and where we've been recently. And Justice Bolick is actually one of those things I grab hold of and say, well, hey, this is good news and a big accomplishment. He outlined his provocative subtitle of judicial activism, and I particularly appreciated his distinction of distinguishing activism from abdication and from lawlessness. Judicial activism as a label really emerges out of the New Deal period as a way of criticizing conservative courts as the New Dealers want to characterize it, being lawless. And it's sort of carried forward ever since as being a way of criticizing courts for really going beyond their duty, doing something else, as the New Dealers and progressives like to say, acting like a legislature rather than acting like a court, making up law as they go. And so the phrase activism's always had a bad odor, and it's over time, I think, lost a lot of very specific content as to what it means. And so people tend to know that you don't like it when you're talking about an activist court, but it's hard to pin down exactly what it is they might be complaining about. So it's a bold move to try to grab hold of the label and repurpose it and dust it off and use it as something positive rather than something negative. One downside of the way in which we've talked about judicial activism for many decades is that it has left us without good language to talk about judges exercising their responsibility to strike down laws in a positive way. And one effort to try to recapture this language of judicial activism is to try to resuscitate some kind of label, some kind of verbiage that we can use to talk about this judicial responsibility. Others are trying out other labels. Some are advocating for judicial engagement as a way of trying to capture this view of judges being active and being on the front lines of enforcing constitutional boundaries. Some talk about the judicial duty, but regardless of which particular language we want to reach for, they're all sort of similarly concerned with thinking that courts ought to not be passive. They shouldn't just sit back and accept laws and be very deferential to what other political branches are doing, but instead should be more aggressive and more skeptical in evaluating the constitutionality of the acts of other branches, and when necessary, striking them down as unconstitutional. That's not only sort of a bold move relative to sort of this kind of New Deal baseline about judicial activism, it's a really bold move within the conservative legal movement. And this was a very controversial stance that Justice Bolick was one of the important people to really carve out and reshape the conservative legal movement over the last many years. As some of you know, that as the conservative legal movement really came together as such, really in the 1970s and into the 1980s, it was formed in reaction to the liberal decisions of the Warren Court, in particular in the early days of the Berger Court. And it was often framed as a rejection of judicial activism, a desire for a more deferential court that was going to uphold law rather than strike laws down. This was the kind of rhetoric and judicial philosophy that people like Robert Bork and William Rehnquist and Antonin Scalia all embraced and advocated for into the days of the Reagan administration in the 1980s, and brought with them to the bench and really dominated the conservative legal movement and in many ways. Justice Bolick was one of those who eventually wound up pushing back, and I think has made an extraordinary difference in how the conservative legal movement, broadly defined, thinks about these issues today. That there is much more support on the political right to as he would characterize, an activist court, a court willing to strike down laws, a court willing to be aggressive and skeptical about what other branches are doing than there was, for example, when I was an undergraduate student during the Reagan administration and beginning to think about these issues myself. This is particularly true among those of a more libertarian bent on the conservative right, but is not limited to libertarians who have taken the courts more seriously. And part of the reason I think they've taken the courts more seriously is not only, of course, the mere political fact, that's also true that there are more people on the political right on courts. And so as a consequence, they're a little more friendly. And as a consequence, people feel a little more sympathetic to them doing things rather than simply getting out of the way. But there's also, I think, an increasing appreciation on the political right of some points that Justice Bolick pointed to about the extent to which other political branches have really defaulted in their own constitutional responsibilities. And unfortunately, this is not new. This is a very long-standing tendency. As he noted, there was a time in American history when members of Congress took their obligations extraordinarily seriously to debate constitutional matters and spent a lot of time and energy in Congress thinking about constitutional issues. They didn't always get it right, but they viewed this as an important part of their responsibility and took that very seriously as they were legislating. And increasingly, they stopped doing that. They didn't take those issues very seriously. They didn't worry about those issues. Increasingly, many more congressmen took the view that ultimately that's the judge's job to worry about the Constitution. It's not our job. And so the best thing for legislatures to do would be to pass laws and policies that they liked, that they found attractive, their constituents demanded, and then let somebody else worry about whether or not they're actually consistent with the constitutional rules or might violate people's rights or the structure of the Constitution more generally. And then somebody else that had to pick up the pieces ultimately were going to be courts. It's also true that executives have over time become less and less interested in caring about constitutional restrictions. That's certainly true about their own activity, but even legislative executives as a component of the legislative process have been much less aggressive in this regard. So if you look at, for example, American presidents early in the 19th century, they thought using the veto power to strike down, to reject unconstitutional bills was an important part of their obligation. Most presidential vetoes issued across the early decades of American history were issued on the grounds that the proposed statute was unconstitutional or it had constitutional defects of various types. Increasingly, presidential vetoes also began to focus on policy issues as well. But what's really striking is eventually the constitutional issues largely disappeared from how presidents explained why they might veto legislation. So not only did that, were the vetoes they issued no longer grounded on constitutional claims, so presidents basically exclusively vetoed things on policy grounds, but almost never out of constitutional complaints. But increasingly, when they did have constitutional complaints, they shifted away from using the veto power to actually reject that legislation and view the presidential role as in part protecting the Constitution from Congress, but instead issued signing statements, such as the one that Justice Bolick described that the Bush administration issued in relationship to the Campaign Finance Act, in which they recognized that there were all kinds of constitutional flaws in the legislation from their perspective, but nonetheless, they were not going to veto it. They're going to pass it along while making a notation on the margin that they have some constitutional concerns and hoping that courts might clean up after the fact. And unfortunately, that's not an isolated incident. This is, in fact, extraordinarily common for the modern presidency. And of course, it's not limited to the federal government. It's equally true at lower levels as well. So, for example, in my book, Political Foundation of Judicial Supremacy, I describe another one of these instances in which the Clinton administration recognized the constitutional problems with the Communication Decency Act, which was designed to regulate the internet and regulate pornographic material as well as other offensive material on the internet. Lawyers from the administration went to Congress to lobby Congress to tell them that this was unconstitutional and they had grave constitutional concerns about that act. Nonetheless, the legislation was extraordinarily popular in Congress. Senators were notably horrified by what could be found on the internet, as one of their colleagues who was a key sponsor of the legislation emphasized to them by having a folder full of pictures from the internet to show them this is the stuff you can find on the internet. And so as a consequence, it became extraordinarily popular. It ran through Congress with large majorities. And the Clinton administration completely folded in the face of that once it became apparent that Congress is going to pass it, the administration did not want to be public in being on the wrong side of this, because after all, Bill Clinton himself had to stand for election soon. And the public seemed to be supportive of this as well. Given that kind of context where members of Congress and members of the executive branch no longer see it as part of their job description to worry about the Constitution, are far more concerned about what will win them re-election than they are about protecting constitutional boundaries, it becomes really essential that courts play an important role in trying to interpret and enforce constitutional requirements. It's worth noting that they are not keeping up And so even the courts that we think of in a modern period as activist courts, they're striking down lots of legislation. It is a tiny fraction of the amount of legislation that's being passed. And so if you look across American history, while it is true that the number of cases striking down laws has gone up over time. That's true in the States. It's true for the US Supreme Court. The number of cases in striking down laws compared to the number of statutes that are being adopted has gone dramatically down. So legislation, even this Congress, which is not the most ambitious in passing legislation, even the recent Congress is passing far more legislation than the court actually substantively reviews and strikes down, which means we're not in a very good place if legislatures are not taking their job seriously. The courts can only clean up so much of the mess, and they're still going to leave a lot of it there. And so we want courts to be playing this role, but at the same time, we also want other political branches and other political officials to take their job seriously and care about the Constitution as well. And finally, I just wanted to note briefly about the particular significance of Justice Bolick being on a state Supreme Court. I think there's a renewed appreciation, both politically and in scholarship, of state courts and what they do. State courts really were overshadowed for a very long period of time by the US Supreme Court and by the federal courts. And people did not take them as seriously as they should. I think state courts themselves often did not take themselves as seriously as they probably should. In part, we see sort of a political dynamic in which those on the political left are turning their eyes to state courts now that they feel like they're not going to get out what they want out of the Roberts Court. And so they're hoping that state courts will be more sympathetic with some of their particular concerns. But I think it's also the case more generally that people come to a greater appreciation of what state courts can contribute to the constitutional system and the importance of state constitutions to the constitutional system. If you'd looked at the 19th century, we would have thought state courts were extraordinarily important. They were doing lots of important work. When scholars created case books of American constitutional law, state courts were well represented as important components of American constitutional law that students ought to know what state courts were saying. State courts were seen as in dialogue with federal judges about what the meaning of the constitutional system looked like. So it wasn't all being handed down in a one-way street from the US Supreme Court and then received by state courts. We still have a doctrine of independent state grounds in which state courts can take advantage of the idea that they can make decisions. They're not going to be reviewed by the US Supreme Court because they're grounding it on the meaning of state laws and state constitutional components in particular, and not directly on the federal Constitution, which gives state courts space to develop out their own constitutional vision and develop out their own constitutional documents to a greater degree. But there is a lot of overlap in the concepts and the rights and some of the concerns between state constitutions and federal constitutions. There are some areas where state constitutions are doing things completely different that the federal Constitution doesn't really cover. And in those areas where there's a lot of overlap, there is a tendency on the part of many state courts to just assume that the state constitution mean the same thing as the federal constitutions, as was highlighted in this particular context about searches. But many state constitutions have different language than the federal Constitution does. They were adopted in different contexts. They were intended to be different things. And so it's sometimes the case that the federal Constitution and the state constitutions are trying to do the same thing. And it makes a lot of sense that the constitutional doctrine at the state level and the constitutional doctrine at the federal level is going to be very similar, or maybe even the same, and that there ought to be a dialogue between those two bodies and thinking out what the meaning of this common set of constitutional rules are. But there's also other areas where state constitutions are really trying to do something different, and state courts ought to be respectful of that and understand that and appreciate that and take advantage of that fact to develop their own independent understanding of what some of these rights are. And some of the rules are restricting what government officials can do and be willing to go their own way sometimes and go in a different direction than the US Supreme Court does in general. I think there's going to be more interest in state courts in coming years in doing that. I think both from a scholarly perspective and a political perspective, there'll be some expectation that state courts are doing it. And some of the work that Justice Bolick's doing right there on the Arizona Supreme Court is reflective of that, of really driving things ahead. And so he's in a very exciting position to be able to articulate a set of concerns that matter on the national scene from the particular place he's located, but also take advantage of the fact that Arizona is its own government with its own constitution and its own set of constitutional rules that need to be articulated and defended. There's lots of room for development. And so for those of you interested in going to law school and moving forward, part of what I hope you will do is pay attention to and think about state courts and state constitutions, because they are really important to the American constitutional system. They are often overshadowed, often not, we don't pay enough attention to them. Certainly at the undergraduate level, but even at the law school level, and they are important. And Justice Bolick is one of those who is helping to make them important right now. So let me end there.
Thank you.
Thank you so much to both Justice Bolick and Professor Whittington. I'd now like to open the floor to questions. So if you have one, just use the raise hand feature. We'll start with Duncan Taylor.
So first of all, we've got a couple people from the UNH Law Federalist Society here. So we're nationwide today. I was actually wondering, Justice Bolick, well, first, thank you for speaking. Sort of reminded me of Randy Barnett's book, Restoring the Lost Constitution. And I actually prefer the term judicial engagement, like y'all have been saying. I was actually wondering how an engaged judiciary would really interface with administrative agencies. And this is not just because I'm taking administrative procedure this semester and I'm slowly going mad from reading the Administrative Procedures Act, but how would an engaged judiciary engage with administrative agencies?
Well, first of all, I was thrilled to write my briefest concurrence in a case when I said, and by the way, very nice to meet you, Duncan. When I was able to write a very short concurrence in a case saying that Arizona had never recognized the Chevron doctrine, I hoped it never would, and citing former Judge Gorsuch's wonderful concurrence with his own opinion in a 10th Circuit case. But I think certainly the judiciary, an engaged judiciary, would never assume that an administrative regulation was valid, and certainly would never assume that an administrative agency's interpretation of the law was entitled to any deference whatsoever. The myth that an administrative agency has some special expertise with regard to interpreting the law and is a disinterested party in assessing the limits of its own power, these are among the most dangerous myths that have been propagated really in the modern judicial era, and as a result have dramatically expanded the power of the administrative state, even beyond the power of the federal legislative branch. And also the notion that we would allow Congress to delegate legislative authority to executive agencies without very, very clear boundaries, I think is dangerous as well. There was an amazing article in the New York Times, and I say amazing because it was so incredibly perceptive, a few years ago, looking at the Trump judicial nominees, at least through Gorsuch's nomination. And they were looking for the common denominator among those appointees. And of course, people would say, oh, they're looking for judges who don't like abortion. They're looking for, judges who have a particular philosophy, and that the Times adroitly identified a common denominator as these judges having far greater skepticism of the administrative state than anything, any other thing that they had in common. So I think we're now entering an era, frankly, probably led by Justice Gorsuch, where the judiciary, I believe, is going to not only reassert its role in assessing the boundaries of the power of administrative agencies, but possibly reassert the role of Congress in passing legislation. So it could not be a more exciting time, in my opinion, for you to be taking this course, because it was about as dry a subject as I had in law school, and it is no longer properly taught to reflect current trends and debates. It's a very, very exciting subject. So thanks for asking about it.
All right, next we'll go to Billy Wade.
First off, thank you both so much for your comments and for enlightening us. Justice Bolick, you make a really convincing argument that the judiciary is essentially the last line of defense for the Constitution from legislators and executive officers who are unwilling or unable to do their homework on the Constitution. But with that responsibility, should there be some sort of check on the judiciary so they don't abuse this activism? And if so, do you see that as some form of departmentalism between the different branches? Or is it something within the judiciary itself?
So that is a really outstanding question, and I am not really sure what the best answer is. The framers of the Constitution felt that an independent judiciary was so important that they invested the judiciary with lifetime tenure. At the time, that was not really a very big deal, because the average age of an appointee to the US Supreme Court was older than the average age of death, which meant that your expectation would be that the person appointed to the court would pretty much die the next day. Today, fast forward it, and the average tenure of a US Supreme Court justice is now over 30 years. It's 8 presidential terms. We relatively recently saw the departure of the final Reagan appointee to the court. Justice Thomas, may serve 40 or 45 years, and I wish him health. This is this is somewhat, to me, a scary phenomenon where you appoint judges younger, they stay for 3 or 4 decades, and lifetime tenure is just not much of a check anymore. So I actually would be very open to the idea of term limits of some sort for judges on the U.S. Supreme Court. That's a tricky subject, but I do think that's not a bad idea. Some in the Federalist Society are big fans of judicial elections. I think this is the worst possible way to go, and I get in trouble with my Federalist Society friends for taking the position that I do, because I've been in courtrooms as a litigator where the judge is looking out at the folks in front of him or her as potential contributors to his or her campaign. This, to me, is not the way to check judicial zealousness. Arizona and many other states have a merit selection system that I won't go into detail on, but we do face retention was noted in my bio that I was elected to or retained for a 6-year term. That seems to be a good a good way of holding judges to their oaths of office, but we are seeing an increasing political influence even in retention elections. That is a bit worrisome. Having said all of that, the ultimate safeguard is appointing judges who really take their oath of office very, very seriously, and who recognize that we are not an imperial judiciary. We are not a super legislature, and to really, for the public to be really scrutinizing of the records of judges who are being appointed, and to play a role in the confirmation process, especially at the federal level. The Senate is the last democratic checkpoint before a person gets a very long lifetime tenure, and we've got to be, very, very, very careful about exercising our democratic prerogative to say no to judges who don't seem to be committed to their constitutional oaths. Thanks for a great question, and hope that was a somewhat coherent answer.
It was. Thank you very much.
We'll go to Abigail next.
Justice Bolick, you mentioned that the courts tend to rewrite laws, and recently there have been some Supreme Court rulings that seem to transform the judiciary into a sort of a legislative mechanism. However, overturning rulings could erode the stability of the courts, and I was wondering if you could comment on the concept of stare decisis, and when, if ever, you think it's acceptable to overturn precedent.
Well, when I took my constitutional oath, it was to the Constitution and not to the doctrine of stare decisis. And for those who don't know what that concept means, it's basically respect for past precedent, and it's a judicial invention that holds that the orderly pursuit of the orderly development of law requires that precedents not be lightly overturned. Chief Justice Roberts recently made a very, very strong stand for stare decisis in an abortion case where he had very strongly dissented in a prior case that was almost identical. And when the case in a different state, actually Professor Whittington's home state of Texas, came before him, he said, you know what, we have this recent precedent, and the fact that a change in the composition of the court has occurred should not change, should not automatically change the law. Having said that, I think that's, and Justice Scalia certainly held this view as well, that stare decisis ought to hold very strong sway where the court has recognized a right that people have come to rely upon, have come to accept and to hold as their own. For example, this argument has held sway in the abortion context, and there have been judges, a number of judges, who have said, listen, I may not have voted with a majority in Roe versus Wade, but this now is such a widely accepted right and a venerated right that I'm not going to change those constitutional opinions. I'm not going to overturn them. I think I find a lot to commend that view. But with a case, say the slaughterhouse cases, I would be first in line to overturn a case like that, where it is atextual. It has served to circumvent rights rather than to protect rights. And so I applaud those on the court who have expressed a willingness to do that. I do think that, and Scalia held this view as well, that the doctrine of stare decisis has a stronger basis in the context of statutory interpretation. If we screw up, if a court screws up an interpretation of a law, presumably Congress or the legislature can change that, and they often do. Whereas with the Constitution, if we blow it, there's really only one entity that can correct that mistake, and that's us. That's the judiciary. So there, I think stare decisis has less vitality. Thanks for a great question, Abigail.
Thank
you. And we'll go to Zach Phillips for the last question.
All right, I get to be the last one. One of those other fellow UNHers. Justice Bolick, I had a question for you. It kind of helped with Professor Whittington, what he was talking about, but how do you as a judge work out, or maybe kind of like articulate or convince other justices and the people when striking down legislation that the people really want, like say that the Decency Act or some other kind of thing, but it's that everyone's like really for, and everyone thinks it's going to be really good for them, but in the end, it's actually unconstitutional to implement that legislation? So
that is a great question, Zach. And I think, I'll bring up Chief Justice Roberts again. I think that Chief Justice Roberts has gone overboard in protecting what he perceives to be the integrity of the court and the popular support for the court by sometimes not doing that, not doing an unpopular thing. And the courts ultimately exist to be counter-majoritarian, to protect individual rights against the majority when they need to do that. There's no one else who can do that. And I guess I'd like to emulate, there are very few politicians I like to emulate, but I've become a fan of Senator Ben Sasse of Nebraska. And every time he casts a vote, he gives a civics lesson to go along with it, to put what he's doing in context, in historical context, in the context of the Constitution. And I try to do exactly the same thing in my opinions. And that is not to start with the controversy before us, but to start with the history of the constitutional provision and how it has evolved or been evolved over time. So that and unfortunately, too few people actually read opinions. They form opinions about the opinions without informing themselves about the opinion. But for whatever it's worth, I hope that when people read my opinions, A, they are comprehensible, and B, they provide the kind of context that hopefully will, even if they are an unpopular decision, they will commend strong support.
Thank you.
All right, thank you so much to both Justice Bolick and Professor Whittington, as well as all of you for coming to the event today. And yeah, have a good evening.
Thank you.
Thank you very much. Appreciate it.
Thank you.
Thanks.